two, this. Number two. So, yeah, that is, I mean, this is a relatively new case, 1997. Board held that installation and use of such hidden cameras is sufficiently germane to the work environment and outside the scope of managerial decisions, blah, 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 right? The court likened the use of hidden surveillance cameras to drug and alcohol testing, polygraph testing, and physical examinations, all of which the board considers investigatory tools or methods used to determine whether employees have engaged in misconduct over which the board has previously held that employers are obligated to bargain. So yeah, that's now a mandatory subject to bargain as it relates to video cameras. I've seen this a few times actually, where employers are wanting to put cameras, over certain work areas and stuff, and you always get the concerns from the union about what the cameras are used for, etc. And those seem to be the big issues there. Number three, we already discussed that. Retirement benefits for future retirees. Again, when you're starting to move away from that employer-employee relationship, it's likely to be permissive, right? What about employee background checks? I think we just mentioned that one as well. That's also a mandatory subject to bargaining. And number six, union-induced checkoff provisions. I wanted to bring this one in. What do you all think? The NLRB just recently, in late 2022, in a case called Valley Hospital Medical Center, found that employers may not unilaterally stop dues checkoff upon the expiration of a CBA, right? So I know this has always been kind of back and forth a little bit. I think 2015, there might have been a case that said otherwise. So this kind of keeps going back and forth. Said this ruling reinstates an Obama-era requirement keeping dues checkoff arrangements in force even after the CBA expires. The board majority found that a dues checkoff provision properly and reasonably belongs in the broad category of mandatory bargaining subjects that Section 8A5 of the Act bars employers from changing unilaterally after the expiration. So again, this is a change, right? And I in my job as a mediator, sometimes if I come into a case that's they're already post expiration, this is often a big issue, right? The employer, prior to this they would stop union dues, and that would be kind of a leverage thing, right? Well, this new board case would say, well, they can't do that anymore, and we'll see. As it probably gets appealed and makes its way back up through the courts, we'll see. But that's just relatively new. Yeah, again, so the board's initial decision on this issue was a Bethlehem Steel case, and it held that employer was free to end dues checkoff upon expiration. The Ninth Circuit later, in 2015 case, changed their mind. So this seems to be going back and forth. Obviously, depending on the makeup of the board, is probably has mostly to do with those items. So 11:54. I have no more presentation, but I'm going to stop sharing and see if maybe we have some discussions. I'd like to hear if anybody has any good stories about surrounding mandatory or permissive subjects of bargaining. So let me stop sharing here for a minute. All right. Anything from anybody? Any stories? Any stories people want to share? Hi, Jill. Yeah, please. Oh, you're on mute.
Sorry, I thought somebody else was starting to talk. So I have a question. I'm curious to get your take on this. So I'm currently involved in negotiating a first contract. It's private sector. Things are pretty contentious, to say the least. And we're having a lot of issues, and I'm union side, where we're introducing proposals and management's just like permissive. We're not going to talk about it. So some of the things are permissive, and we realize that, but some, I don't think it's perfectly clear because, there's not like some things are clearly defined, but others aren't. So like that, it's just kind of a gray area. So one that I'd be curious to get your thoughts on. So again, it's private sector. We have proposed language that we would have some information on when the board of the company meets, like a meeting calendar, when they meet, would employees ever be able to attend the meetings, ever be able to speak with the board or like address the board in a meeting. And our argument is the board is making decisions that impacts the members, the employees, their terms and conditions of employment. But management won't even talk about it. They just say permissive, permissive, permissive. Do you have thoughts? I guess I have two questions. One on this board meeting question that I have. And then two, just any suggestions on when the two sides can't even agree if it's mandatory or permissive, other than filing a ULP?
I mean, yeah, I mean, I think that's your route, right? That's your avenue is the ULP. On the first one, I don't know. I mean, it's almost akin to that one case where, you know, the employer is going to have a wide discretion to be able to run their organization kind of as they see fit, especially if if they're discussing things at these board meetings that are, I don't know, you know, private or held private, or they believe that, you know, shouldn't have any more ears there. I don't know. Again, I'm not an expert on this. And again, remember my disclaimer, but I would think that would likely be seen as a permissive subject, to be honest with you, because I think it gets away from, yeah, I mean, the employer is going to make decisions and it's going to affect, I mean, that's just the nature of an employer-employee relationship. They're going to make decisions that are going to somehow impact but I think in the courts, as this evolved, they're given wide discretion to the employers on these type of things. That's my take on it. As far as the other one, yeah, I mean, that's a good point. I would love to hear from anybody else, because again, as an advocate, I never really I did mostly public sector, so never had a lot of these issues about, you know, mandatory and permissive subjects. That's why I really wanted to dig into this, because I was, you know, it's kind of fresh for me. But I would like to hear other people's comments on that. But I'm guessing your route is an unfair labor practice, right? Refusal to bargain on what you believe might be a mandatory subject of bargaining, right? And I think the board would have to decide that, right? I'm guessing, and I hate to say this, but it seems like, you know, it's been what, you know, since 1947, what are we, like 80 years of bargaining this stuff. It seems like every provision should have some kind of decision out there by now, but I know that they're probably not, right? There are some things that are probably still in the gray area. So Jill, I don't know if that answers your question, but you know, I'd love to hear anybody else's response to that. Brian, I mean, you have any thoughts on what you believe that to be?
You know, some of these things aren't clear, and I think you run into differences too between public and private sector. I mean, I think you're going to be more restrictive in private sector on your ability to raise grievances with at a board meeting, as opposed to public sector where you have First Amendment rights. I think the same thing could be true, you know, with the previous slide you had on things like dues checkoff. What if the legislature goes out and passes a law outlining dues checkoff? You know, it's going to be a little bit different maybe, and you know, you have SERB that has a balancing test on that. Yeah, you know, I think, you know, with a new contract and that, and speaking as a union advocate now, you know, I would push the boundaries, maybe consider an unfair labor practice, even if it might not get traction in the long run. It may give you leverage bargaining.
Yeah, that's a great question, Jill. I mean, I wish I would have experienced that in my time as an advocate, because that's something that would be good to know. I mean, I'd be curious on how that turns out. Yeah.
I have a question, kind of along the same lines. Well, as far as really what traction or teeth does a ULP get you? And I've seen some ULPs where, you know, it was really almost no remedy other than go and hang this up, you know, stating that you've lost or you violated. So it kind of, so when you know, I was a union advocate for the city of Cleveland. The city of Cleveland, you know, not disparaging the city of Cleveland, but they kind of be kind of tough, and they were unfazed about ULPs, you know, that if we, you know, made a threat or even did it, it really didn't faze them. But I've never seen any real remedy. Now, Joe, I think I heard you say something to the effect about issuing a cease and desist. So I just want to know what effect a ULP can have, other than kind of going through what real remedies can come out of a ULP.
Well, it probably depends. If you're talking public sector, private sector, obviously, I mean, you'll see it's very common. I'll walk into negotiations in the private sector and there's already a ULP been filed, right? And they're filed for one reason only. Well, I shouldn't say that. They're filed for purposes, there could be legitimate ULPs obviously filed, and there are. But in the private sector, obviously, if negotiations fully break down and there's a strike, they need to strike on a ULP. They can't, if they don't have a ULP filed, then it's essentially probably an economic strike. And then we get into the issues there where, the employer can permanently replace employees and those things. So a ULP during negotiations in the private sector means quite a bit, right? It gives the union protection. Now, if your experience, Cedric, is in the public sector, which is, I was a product of the public sector as well. Yeah, I mean, the ULP, I mean, it was always, we always kind of joked like, oh, okay, you're going to file ULP, they'll stick a notice on the wall and shame on you. It really depends. I'd like to hear Brian came out of CERB. I'd like to hear Brian's response to this, but yeah, honestly, I've never really had a ULP that had a significant impact on whatever we were doing. And I don't want to run into the next presenter's time, but Brian, do you have any thoughts on that?
Again, it may not have a lot of impact. Early on in the collective bargaining law, you saw this issue being a lot more significant. And in recent years, it hasn't. But, I could tell you there was a significant outcome in a state of Ohio case in the late 80s where the state of Ohio made unilateral changes to healthcare because of increases that it experienced. And it resulted in a hard to believe from CERB, a 300,000 plus finding against the state of Ohio. One of the unions filed an unfair labor practice over the change. I think what you've seen is a change in the way employers approach healthcare. They try to make it a lot more open-ended. You have 3-year contracts in Ohio, and every year healthcare changes are coming through. Adapting to those type of changes, I think, the employers have demanded more flexibility to respond to those kind of changes, and it's become kind of a non-issue. I don't know if that's really responsive, Cedric, to your question, but you're not going to get a lot out of it. And typically when you file an unfair labor practice around bargaining, you'll get one right back.
Or it'll get kicked to, like, a lot of times unions will file both a grievance and a ULP, and the ULP they'll defer to the grievance procedure, right? A lot of times.
Well, I'll tell you, having worked at CERB for a number of years, if you file an unfair labor practice during bargaining, they will expedite the processing of the unfair labor practice. And a lot of times, if you're not in mediation, they'll demand mediation, and that can be a helpful thing.
Yeah. Thank you for the question, Cedric. I hope we.
Yep, thank you.
All right. I don't see no other questions. John, do you want to go ahead and take over from here? I appreciate your all's attention, and Brian, thanks for the questions, and Cedric as well. Thank you all. And Jill. Yep.
Thank you very much. We can take a 5-minute break real quick just to let everybody stretch their legs, and we can then jump into the next segment if everybody would like to just take a quick break. 5 minutes and we'll come back. Thank you, Commissioner Joe Wilson.
Yep, you're welcome.
Very much enjoyed your presentation, Joe. Very helpful.
Thank you, John. I appreciate that. Again, yeah, I don't presume to be an expert on it, but it interests me, it really does, because it springs up, especially in my mediator role sometimes, so it's always good to dig into this stuff. And
no, it's great that you have all those different perspectives to bring, the employer, the union, and the neutral. That's really helpful.
Yeah. And I hope, because when I started doing this, I'm like, okay, all I'm doing is court cases, but really that's how this issue evolves, right? I mean, that's how these things are, right? And usually people like hearing about cases and stuff. So that's why I kind of wanted to go that route. Yeah. I mean, there's a ton more, right? A ton more cases out there that could be,
books have been written on it.
Yeah.
But it's good to be reminded of these things too.
Yeah.
It's always good to get a refresher.
Yeah, I mean, that was a great question by Jill. I've never experienced, an employer just, no, I'm sorry, that's permissive, and like that could be frustrating. I could see that being frustrating from a union perspective.
Oh, yeah.
Yeah.
I was wondering if any of that information could be obtained through the duty to provide information as part of the bargaining obligation, the 10A5 or the 8A5 duty to furnish information. I don't know.
Yeah, that's one of the, I mean, honestly, in private sector cases, that's one of the biggest issues that I hear walking in is information, one side, normally the employer just not giving information out, and that frustration that it causes all the time. It's almost like every private sector case I've done has some involvement with, we're not getting information, right?
Yeah, I've seen it a lot as well.
Yeah. That's why, I mean, private or public sector, you got the public records law, right? I mean, it's pretty easy to get stuff, for sure.
I did want to compliment you on how succinct your summary was on the historical lead up. It was great. I think it was not complicated. It was easy to understand. That's one of the most common things we get when we're talking about it is why. And, it was perfect. It was like, this was the foundation. This is where and why we are today. And it's perfect timing too, because where we are right now in history.
Yeah. Thank you, Kate. I appreciate that, because I went back and forth on, as I dug into this, I thought, well, it's really important to understand what the NLRA was meant to be for, because that impacts a lot of what cases came after, right? So yeah, I appreciate that. I'm glad it came across.
Exactly what's going down at this time in history, and it reminds us all of how this came to be. So I thought it was perfect without getting too much in the weeds. You see. See how it came to be, and seeing what's going down now, you see why it came to be. So
yeah, thank you. I appreciate that comment.
And with the trainings we do, I want to possibly, I won't say plagiarize, but remember, maybe pull a couple pieces of this in, because, like I said, a lot of times people really get stuck on why do we have certain things? And I'm like, well, because you cannot have disruption in the workplace, especially in the public sector. So I think it was great. So thank you.
Yeah. Now I'm guessing, like, if the NLRA were to start today, it would be completely different, probably. You know what I mean? So, like, just looking at it in that scope of when all this went down in the 30s and 40s, right? Compared to like today. So it's just it's very interesting to put that in perspective as well, right?
Yeah.
And then, of course, you get different boards, you get different Supreme Courts, you get all of those factors playing in as well. So, yeah.
I'm always impressed when people can take such a big issue and just boil it down to the basics, and be very eloquent. So great job.
Thank you.
I wish I was that eloquent.
Oh yeah, I always, I'm one of those, I'm hard on myself. I'm like, I know I probably sound horrible on the screen. So that's much appreciated, Kate. And I was wondering, I'm like, because Mita told me, she said, well, there's not usually a lot of questions, so you'll need to speak for an hour. And I'm like, holy crap, I hope I have enough, hopefully I have enough information to speak for an hour. And it turned out perfect. So I'm going to stick around for John's presentation, if you all don't mind, even though I'm not a member of your organization yet, maybe.
Absolutely.
I did get something in the mail, though.
Absolutely, yeah. If we're in person, we tried to feed you if we could, but yeah, definitely love you to stick around.
And actually, Joe, if you do need CLE credits, just let me know. and I can make sure that you get them as one of the speakers.
Oh, okay, yeah, no, that's okay. Appreciate it.
I was gonna say it's good PowerPoint presentation and with the cases and citations, and you're gonna cause me to go do some homework. So just,
Well, whatever you find, Brian, send it to me, because I like to, put this stuff in our little arsenal as well, because you never know when someone's gonna ask for some kind of training related to this or something.
yeah, I hadn't realized you were down in Cincinnati now,
Yeah, I'm down here with John.
Yeah. Give my regards, please.
I will. We don't see each other anymore since we've been kind of working from home, we don't, I'm in the office today, but we're not really required to be anymore. So I don't see him as often as we used to, but I sure will.
No, thank you.
And Kate, I think we are ready to start from break again if you are.
Sounds good. Do you need everyone to log in with their CF?
Yes, I will put it in the chat box again, please.
All right, if everyone would please pay attention to the chat box, and as I stated earlier, we do have another speaker. I have to look at my participant screen. And John, did you want to share your screen now for your presentation?
Yes. I didn't do as much. I'm not going to be as professional looking as Joe's presentation. I just have a Word document, but I thought it would be helpful to go along that. And I'm going to see if I can get to as much of it as I can. There's a lot of information here, but if we don't get to it all, then I can provide this documents to the group leaders to get to everybody. Okay, I'm going to share my screen, and that is not what I wanted to share. Are you seeing? Are you seeing a photograph of the Rhine River?
No, management rights.
You're seeing the management rights. Great, excellent. Okay. All right. So I also have a disclaimer, just to let you know. I am an attorney in Massachusetts. I'm not very familiar with Ohio law. I've tried to bone up on it in the last couple of days, but I apologize if I made any mistakes about Ohio law, and would be welcome to anybody who wants to correct me if I get it wrong. I do notice one big difference between Ohio and Massachusetts is that public employees in Massachusetts have no right to strike. I'm glad to see that we're both not right to work states. So that's good from my perspective as a union advocate. And it's hard to divorce my position as a union advocate. I've been doing this for 25 plus, just 26 years. So if I start sounding biased in favor of unions, I apologize. It's in my blood now. I've been asked to talk about management rights and sort of the interaction or the differences between management rights and terms and conditions of employment, what Joe has been talking about as mandatory subjects. I think that one way to start talking about it is to say, to first sort of say what are management rights in a non-union context. So let's say we're in we just have an employer. They don't have a union. What can the employer do? The employer is they can decide what the business is going to be. They can decide how they want to run the business. They can decide where they want to run the business, who they want to hire, what they want those people to do. They can decide what equipment they want to have, what procedures they want to use, pretty much everything involved with running the business. They can decide what they want to pay their employees, although there are some restrictions on that. They can decide how many hours the employees work, which hours, what schedules they have, how many employees they want to have. These are all things that are considered management rights in the abstract sense, in a non-union setting. But important to recognize that the legislatures have imposed significant restrictions on what employers can do. So employer management rights are not unfettered even in a non-union setting. You have, and I've just listed a few of them, the Fair Labor Standards Act, which sets a minimum wage for the nation. You also have a minimum wage for the state of Ohio under Chapter 4111. You have rules about when time and a half is required, usually after 40 hours in a week. Overtime pay is required. That's both under the federal and state. You have non-discrimination laws in both federal and state for various categories: race, sex, ethnicity, national origin, religion, all sorts of different categories. There's an Age Discrimination and Employment Act. There's OSHA, which is a very big imposition or a restriction on management rights. You can't run an unsafe or unhealthy workplace. Or you might get in trouble with the feds. Of course, if the feds don't hire enough inspectors to go around and look at the employees' workplaces, that maybe have fewer teeth than some of us might like, but still the law's in place, and there are certain penalties for not having a safe or healthy workplace. There's the WARN Act for large employers who have to give notice of upcoming layoffs. They have to have certain retraining programs for laid off employees. There's the ADA, which is disability discrimination. The FMLA, which requires 12 weeks of leave for employees, certain qualified employees for time off for their own medical condition or for that of a family member or for the birth of or adoption of a child. You have the National Labor Relations Act, which Joe just talked about, which even in a non-union workplace does protected concerted activity by employees. So if a bunch of employees get together and they go to the employer, even though they're not in a union, and they take certain concerted activities with regard to their wages, hours, and employment, terms and conditions of employment, they are protected. So the employer can't fire them, for example, for engaging in protected concerted activity, even in a non-union workplace. There's the Whistleblower Protection Act. And the state of Ohio, as you can see, has a number of similar provisions. They have a higher minimum wage than the feds do. They have anti-discrimination provisions. They have restrictions on child labor and labor of minors. They have their own public employee, their own sort of mini Wagner Act for public employment, the CERB that we've heard about before. They have their own whistleblower law. They have their own safety in the workplace law. So, the first sort of point I want to make is management, the employer is already significantly restricted in what it can and cannot do, even in a non-union setting. So what happens when a union comes in? Well, there's a number of different theories about this. One theory is called the residual rights theory. The residual rights theory basically says that anything that's not bargained by the parties into a collective bargaining agreement is a management right. that basically anything they don't talk about at bargaining, the employer can do whatever it wants. You don't see this concept has been adopted by some arbitrators. In certain circumstances, they will say, well, and they've even gone as far as to say that you don't even need a management rights clause in the contract, because sort of the natural state of the world is management has all the rights, and that the only way you can chip away at that is by bargaining specific things into a contract. Now, as you've already heard from Joe's presentation, that concept, the residual rights theory, comes squarely into conflict with the laws set up by the NLRA and the state of Ohio labor laws, which say that certain mandatory subjects of bargaining are mandatory subjects whether they're in the contract or not. And so, you know, I'd say the residual rights theory is something that is more of a aspirational thing for some employer theorists and advocates than it is a practical concept. But I think it's important when you, especially when you see that there are some tensions between arbitration law and unfair labor practice law under the state and federal labor boards, because there are some arbitrators who still ascribe to this kind of residual rights theory, and it can be a little bit concerning for when you're trying to figure out something like, do I file a grievance or do I file a ULP or do I file both over something that the employer did, which we'll get to a little bit later. One of the things that I think sort of astonished me when I was doing research for this, because it doesn't really come up as a practical matter. Joe gave you the list of the most common examples of permissive subjects, the things that have actually gotten litigated and people have gone to unfair labor practices about. We had a question from one of the participants about, you know, what's permissive, what's mandatory, and having employers saying it's all this is permissive, that's permissive, etc. My understanding of the law, and somebody correct me if I'm wrong, but I think this is really true, is that if it's not illegal and it's not a mandatory subject, then it's permissive. And that means that there is a heck of a lot of stuff that is under permissive. For example, I'll give you the craziest example I could come up with. An employee, a union comes into a union for that works in a auto manufacturing plant, goes to the bargaining table, and the first proposal in their collective bargaining proposals is, we want to stop making cars and start making bicycles. That is a permissive subject of bargaining, but it is a subject of bargaining. And the fact of the matter is, if I'm using an extreme example to make the point that pretty much anything about the employer, you know, a proposal to change the name of the company, a proposal to, change the governing structure of the company, a proposal to, not only just to be able to know when the board meetings are, as somebody was pointing out, or attend the board meetings, but a proposal to be on the board, a proposal to change what the criteria are for selecting board members. Those are all bargainable subjects. They're not mandatory, but they're bargainable, which is kind of an amazing thing when you think about it. I was reading an article where they said you know, in an unusual situation where a union had a lot of power and an employer was very weak, they would actually, the union has the potential to really change the way the company works, change very basic facts about the company. So I think that's helpful to have as a background to say, wait a second, permissive subjects is a huge concept. In practice, I understand we're all trying to figure out, you know, how does this apply to my case that I have tomorrow? You know, most of these topics aren't going to come up. The big crazy ones, nobody's going to decide they want to propose bicycles instead of cars. But I think it does help to say that when you're bargaining about management rights, you really are starting from scratch in a lot of cases. Now, I'll put a very big asterisk on that for Ohio public employment bargaining, because the legislature, the Ohio legislature, in its wisdom, has decided to put basically a management rights clause in the statute, which saves the employers a lot of trouble. But the basic concept in the private sector certainly is that you can bargain about everything except for this very, very narrow list of illegal topics. Whether you want to waste time talking about things that are clearly permissive is another question, but it is something to be aware of. So another thing that struck me as really odd was when I did some research on this was I came across two different studies, one from the 90s and one from a little earlier, that said that one of them came out with only 60% of collective bargaining agreements have management rights clauses. And another one said it was about 80%. And that struck me as odd because I can't think of a single collective bargaining agreement I've ever come across that didn't have one. So I don't know where they're getting their contracts from, but I've seen more contracts without just cause provisions than I have contracts without management rights clauses. But anyway, that's what they say, that they're, and maybe in Ohio it's not as necessary because you, like I said, you have it in your statute. But one of the things that most collective bargaining agreements have is a management rights clause. And one of the things that I wanted to talk about was kind of how you can, all the different kinds of management rights clauses and what kinds of sort of bargaining issues come up with regard to those, because it turns out that what's in the management rights clause really does matter. And I'm going to change my thing here. So the very first one I have is kind of along the residual rights theory of management rights clauses. The employer reserves and retains solely and exclusively all of its rights to manage the company, its activities and operations. You know, that is as basic as you can get. And you don't see a lot of these anymore. When I first started practicing, I did see them once in a while. But most places have started doing the enumerations of rights where they list them out. The second one that I'm showing here is a little more fleshed out. They talk about the management of the premises, the direction of the workforce, the authority to execute all the functions and responsibilities of management, including but not limited to, they always have that, but not limited to, the right to schedule work, control and regulations of equipment and property, determination of reasonable published rules of safety and conduct, maintain discipline. And then there's the clause that the union attorney got it put in there. Well, actually, union attorney probably put in the reasonable, and the union attorney probably put also in, except that such rights, functions, and responsibilities are subject to and shall not be exercised in such manner as to conflict with any of the provisions of this agreement. So that's one of the ways that you kind of get the management rights clause to be a little fairer to the union. As an employer representative, you are looking to basically say, you know, the employer representative in example 2 is a little less confident about the residual rights theory. They feel like it's a little better when you just start listing things that we have the power to do and not just say we can do everything we've always done unless the contract says otherwise. You know, this first example, I would say is very unusual in the sense that it doesn't say except as provided in this agreement. At the very least, I would want to see something that says that. So the second one is a little more. Now, the third one I got off an employer attorney website. So it's not in, as far as I know, it's not actually ever been bargained into a contract, but it's kind of like the dream for a management attorney. This is their fantasy of a management rights clause that has pretty much everything in it. And you can see it goes.
Hey, John.
Yeah.
We're still seeing your one Word document. I don't think you ever switched over. Did you switch to another document?
Yeah, I'm sorry.
Oh, it's okay. I just wanted you to be aware of it.
Thank you. I'm okay. So I'm sharing screen.
I think it will usually let you select the screen that you want to share in Zoom.
Okay. So
There you
There
go.
Yeah.
So yeah, so here's the first one I was talking about. Like I said, very unusual, basically following the residual rights theory. I would say as an employer, as an employee representative, as a union representative, I would at least add to this. I'm not really unhappy with this. I kind of like it because it doesn't go into too much detail. And when I'm talking about, you know, interim bargaining of unilateral changes, they can't point to anything and say that they've already bargained over it. But I certainly would like to say as you know, except as provided otherwise in this agreement, at the very least. The second one, they do have an except clause at the bottom that says, you know, can't conflict with the provisions of the agreement, but they are getting into this including but not limited to provisions, you know, where they're basically, you know, they don't separate it out the way the other one does, but you know, it's
Hey, John, would you agree that an arbitrator, even if there was no language like, you know, that accept language, would you agree that most arbitrators would probably infer that all of the articles in the collective bargaining agreement are restricting management rights, right?
I agree. Yeah, I agree. That definitely would happen. And I'll talk a little bit more about other things that arbitrators will do to sort of level the playing field a little bit. This one, the one I was talking about, the sort of the fantasy, it just goes into, and I won't go through it in too much in detail here, but it just goes through on and on and on with all the specific things that the employer has the right. And the basic idea here on behalf of the employer representative is they're trying to preclude having to bargain during the period of the contract. They're trying to create as much leeway as they can during the period of the contract that they don't have to bargain about the changes that they're going to make, as long as they fall within the, you know, the more specific, the better, so they can prove that there isn't they haven't violated, you know, basically they're saying the union has waived, by agreeing to this management rights clause, they've waived the ability to bargain over these things during the period of the contract. One of the things that I always do as a union attorney is whenever they mention discipline in the management rights clause, I always put in for just cause, or I always propose to put in for just cause. There are a lot of contracts have a separate provision for discipline and discharge, but if there's mention of discipline and discharge in the management rights clause, it's always nice to avoid, you want to avoid having a conflict where it doesn't say this just cause here and it says just cause over there. It's not consistent. It gives the arbitrator more issues to have to resolve. It's a lot simpler if you just have that in there as well. Yeah, and then there's this, language at the end. It's understood and agreed that the employer, I should have said employer here, does not have to rely on the collective bargaining contract for various things. It's really, a lot of this is basically going according to the idea of that you're not, the collective bargaining agreement isn't the only the employer wants to take the position that they have all sorts of rights, and the collective bargaining agreement only says some of them. I don't think that most arbitrators would agree with that, but they throw it in there anyway. So I'm back to the my outline here, and I just a few practice tips. What things that usually get included in these management rights clauses by union side is except, adding in except when, that this doesn't apply if there's a specific provision of the agreement that addresses the issue, or that when there's a conflict between the management, sometimes they say when there's a conflict between the management rights clause and another provision, the other provision will prevail. One of the things that I've tried to put in some collective bargaining agreements is this provision that says except when that they're allowed to do it except when required to by law to bargain over it. And that kind of, you might say that's a little bit of circular logic, but it's the idea is if the National Labor Relations Board in the private sector or the state board in the public sector says that something is a mandatory subject to bargaining, that throwing that clause in the management rights can say, hey, you agreed right here to bargain over things that are bargainable under state law. So it doesn't really matter what your management rights clause says, because you also agreed that you would abide by the collective bargaining laws. It would have to be more specific than just except when required by law. It would have to say something like when notice and an opportunity to bargain is required by law. Like I said, I like to put reasonable rules in there, but like Joe said, it's not necessarily required. I like to put just cause when there's a mention of discipline. Another thing that is in a lot of arbitration, another way that employers like to try to nail down what can be bargained about and what can be done during the period of a contract, so that they don't have a lot of have to deal with interim bargaining, is they put in something called a zipper clause. Now I'm going to show you some examples of zipper clauses, and I think I figured out how to do this right. Let me open it up. Okay, I'm sorry, it's not popping up here. There it is. Okay. Okay, so a really basic zipper clause that just says this agreement is the full and entire understanding of the parties regarding the matters herein. It may only be modified, but only in writing upon mutual consent. That's a very, very a very tame zipper clause. I rarely see those. The one in the middle is more common. And this is a really tight one. They're really trying to zip it up, just like the name zipper clause. They're trying to make this contract so that you can't talk about anything else until the next time the contract is up for bargaining. Any changes the employer makes in new topics, you know, there aren't specifically violating, you know, the specific provision of the contract. Anything new that comes up, they can do it because it says that the parties had a chance to talk about everything in the world. And if they did talk about it, or even if they didn't talk about it, if it was, if they could have talked about it and they didn't, that means they're done for the period of the contract. Now, we'll talk later about how arbitrators interpret these, but let's just say that they don't always, they're not as, their bark is worse than their bite. Let's put it that way, these zipper clauses. The third one is kind of a middle ground. They really only talk about mandatory subjects of bargaining, whether or not included in this agreement. And then at the end, I like whoever did this, it wasn't me, but whoever union attorney said, but as to any such matter over which the contract is silent, the employer retains the right to make changes, but only after prior consultation of the union, notice and an opportunity to bargain to the point of agreement or impasse, which I think kind of eviscerates the entire beginning of the sentence of the provision. So if you give me a zipper clause like that, I love it. It's pretty much unzipped, so to speak. But let me get back to my. Let me get back. I'm just having a little trouble here with the. There we go. All right, so back to my outline. Another thing that will make a difference depending on is depending on how you phrase the definition of a grievance in your grievance procedure. Is a grievance a dispute over any terms and conditions? That's going to give you a lot more leeway when it comes to filing grievances over unilateral changes. Or is it only, which is more common, a dispute over a violation of a specific provision of the contract? That may be make it a little more difficult for you to file a grievance when there's an unfair labor practice situation, a unilateral change situation. Not to say that there aren't other ways to do that, which we'll talk about. Another thing that's very common that employers will put in and is very common provision is a limitation on the arbitrator's powers. So there's very often you'll see language that the arbitrator can't add, subtract, change, renegotiate the contract, that they're basically there to interpret the contract, not to add things or take things out. That's a way of employer representatives trying to avoid having to arbitrate issues of involving changes during the term of the contract. A past practice clause, not essential because arbitrators will very often look to past practice, whether there's a past practice clause or not, but it's nice to have one if you can get it. One of the things that a past practice clause will affect is next term bargaining. I've always taken the position that if there's a past practice clause that they have to, they can't just stop a practice, announce that they're stopping a practice and then go forward. You have to actually bargain it at the main table. The recognition clause, this is the clause that says the employer recognizes XX union as the exclusive representative for bargaining of wages, hours, in terms of conditions of employment. That has actually been used by many unions, that provision, as grounds for grieving changes that occur during the term of the contract. Basically saying that that recognition clause incorporates the mandatory subject of bargaining, mandatory subjects of bargaining rules of the labor boards. And I already talked about the wide range of permissive subjects. So we talked about non-union scenarios. We talked about sort of the origin of management rights and what the scope is. Then we talked about what kind of things do you bargain when you're bargaining a contract that affect management rights versus, you know, the tension between management rights versus terms and conditions. Now we're going to talk about the grievance arbitration and contract administration. So, and I see my time is getting short here, so I'm gonna sort of try to skip to the main things. The Steelworkers Trilogy, 1960, Justice Brennan, very important for labor law. One of the things that was in there, it says, if you have an arbitration clause and somebody files a grievance, that there's a presumption that that grievance is arbitrable. You have to basically prove that it isn't. The other side has to kind of prove that it isn't. That's not to say it's always going to prevail, but there is this presumption that we want these disputes to get resolved by arbitration. There's a public policy in favor of that. And so that helps the union because, you know, we heard Cedric earlier talking about the limited remedies provided by the labor boards. Now, I have had good remedies. I've had status quo ante remedies that have significantly benefited people. I've had people reinstated by labor boards. So those are pretty big deals. The status quo ante remedies can be, you know, as Brian was saying, you know, thousands of dollars in restitution to put things back the way they were before you made the change and then bargain going forward. But ultimately a bargaining order, in order for the parties to sit down and bargain, is not as powerful a remedy as something that an arbitrator can do. The other thing that my experience in Massachusetts is that arbitration tends to be faster than the unfair labor practice proceedings, although if there is this expedited procedure that Brian mentioned, that may level that out a little bit. So there are a lot of reasons why a union would want to set up their contract in such a way that they can arbitrate as much as they can of their disputes without having to go to the unfair labor practice route, or to be able to do both. You know, as Joe was saying, in the private sector, very often the ULP is the way to avoid strike replacements, which is a pretty big incentive. Arbitrators will very often, even in a management rights clause, it doesn't mention this, arbitrators will very often put in imply a reasonableness standard for interpreting contracts, including interpreting management rights provisions. They will also sometimes, another way of saying reasonableness is that it may not be arbitrary and capricious. You see this a lot in arbitration decisions where arbitrators say, you know, I'm not going to interpret the contract in such a way that, you know, it's you know, that they can do anything they want, that the employer has this incredible discretion to do whatever it wants. It's got to be within some sort of range of reasonableness. Past practice, you know, just briefly to go over past practice in terms of grievances. You know, past practice matters. Even in a situation where you have a zipper clause that says we've talked about everything and everything's got to be written down, arbitrators will still look at past practice. The way that they'll look at it most the way that you can get, I would say the strongest past practice case is a case where they're using the past practice to interpret ambiguous contract language. So there's language about the subject, but it's a little unclear about what it means or how it should be applied in this situation. Very common. The arbitrator says, well, what have people been doing? How have they been doing it? The one that maybe bumps up against the manager rights clause the most is what we call independent past practices or gap filler past practices where there's nothing really in the contract that addresses it. And it's just, this is the way it's been done for years and years and years, or if you can prove that it's an actual consistent past practice, it's acknowledged by both sides. You know, those are the situations where sometimes the employer will come in and say, I don't care if it's a past practice. We have a manager right to do the opposite or to cease the past practice. And it's not a mandatory subject of bargaining, for example. And that, you know, can go either way depending on the facts. And then the least likely to succeed past practice argument is the argument of past practice that contradicts clear contract language. Although I do know of one or two cases over the years where that has worked, and it usually is in a case where there's some evidence that the parties have repudiated the language in the contract. But it's more common to see the result of, you know, if one or the other party wants to enforce something in the contract that hasn't been enforced for 25 years, most arbitrators will say that's fine. It's in the contract, the language is there, and I don't care that you did it differently for 25 years. We're gonna do what the contract says. The language just has a meaning. I'm gonna skip ahead. So that's sort of in the context of bargaining. Now the time and most of the cases that Joe talked about, and I think where this really comes up the most is in interim bargaining. It does come up like we heard from Jill, I believe it was, that the distinction between mandatory and permissive comes up in bargaining itself. But where the most of the case law and most of the decisions that have come out have been talking about this issue of what about interim bargaining? What about what happens when the employer when the employer does something or proposes to do something within the period of the contract that doesn't specifically violate a specific term of the contract. So it's not like it says, you know, you shall, you know, I have a lot of contracts that say you get overtime for any work outside your scheduled shift, which is a better deal than the FLSA, and a better deal than I think the state of Ohio's overtime law. So, you know, if you have to work a double, you get overtime for the second shift, even though you haven't worked 40 hours that week. Let's say the employer says, I don't want to do that anymore. We're going to just stop doing that. That's a clear violation of the contract. But there are other things, many other things, you know, we want to introduce a new technology. We want to change this, we want to change that. And there's nothing really in the contract that says we can't. And there is language in the contract and the manager rights provision saying that we have control over the means of production. We have control over technology. We have control over this and that. So then you have the issue of, you know, is it a mandatory subject of bargaining? If the employer is not sure, or if it knows that it's a mandatory subject, or it's not sure, what the better practice is for the employer to come to the union and say, give them notice and an opportunity to bargain. And then the union has an obligation to demand to bargain. I can't tell you how frustrating it is to have one of my union people call me up and say, the employer gave us notice that they were going to make this change. And I said, well, what happened? They just went ahead and changed. And now we're really upset about it. And I said, did you ask to bargain? No. Were we supposed to? You know, I mean, that can be very frustrating to hear after the fact that your union seems to think that the employer has to do all the work. The union has an obligation too. They have to say, we want to bargain about this. They have to sit down. The other thing is they have to actually have a negotiation back and forth. So the general rule is if you reach impasse on interim bargaining, then the employer can implement its last best offer. What I advise my clients again and again is don't reach impasse. But there are some cases out there that, you know, there's one case, I don't remember the name of it, where the union just kept delaying setting up the next meeting, and they were hoping that that would be enough to avoid impasse. Well, the court said no, that's ridiculous. You have to actually have a back and forth. The union can't walk in and say, the employer, you know, says, I want to make this change, and the union says, no way, absolutely not. We absolutely 100% disagree with that. Well, then the employer is in great position because they can say, well, it looks like we've reached impasse and now we're going to implement. So you have to actually have some back and forth. And sometimes that's difficult to do, you know, which is why it's always better to be at the main table where you can horse trade and go back and forth and give this for that. When you're just there and it's one issue on the table, it's pretty easy to reach impasse, and it's tough. The issue will come up very often before you even get to that point where the employer says, I don't have to bargain with you because it's not a mandatory subject. And that's when you start getting into, do we file an unfair labor practice? Do we file a grievance? Do we file both? The union, the employer will sometimes say you've waived by contract, you've waived the right to discuss about this, either through the manager rights clause or the zipper clause. And I just want to point out, I'm hoping that Ohio has not adopted this for the public sector, but for the private sector, the Trump NLRB came out with a case called MV Transportation in 2019 that essentially overruled the clear and unmistakable standard for waiver. I don't think that Ohio has adopted that. I know Massachusetts hasn't adopted it. And there is some discussion that the new board, once Biden gets enough people on the board, that they're going to overturn it again, which is one of the frustrating things about dealing with the NLRB, is that they're very politically, they have less, let's put it this way, they have a lot less respect for stare decisis than your typical board. And certainly the board, I don't know about the SERB, somebody could maybe chime in on that, but I know in Massachusetts, the local labor board has a lot more respect for stare decisis than the NLRB does. But you know, for many, many years, clear and unmistakable was the rule for the feds, and at Metropolitan Edison was the Supreme Court case that kind of agreed with the board on that. And then MV Transportation comes out in 2019 and kind of throws a monkey wrench into that. The other thing that you want to talk about, one person I saw put a question up about this, even if the decision to do something is a manager right, the impacts of it on terms and conditions of employment are still bargainable. The difference is that when you have decision bargaining, you don't have to, they can't implement the decision, they can't make the change until they bargain. And if you're at the file an unfair labor practice, that's what I was talking about, status quo ante remedies, that you can go back and you can say, you have to go back to the day before you implemented this. You have to make everybody whole who was affected by it. If they lost wages, if they lost overtime, they lost days off, whatever it was, you have to make them whole, and then you have to bargain. If it's impact bargaining, they can do the decision, they can make the change and then bargain with you. It's a lot less powerful. And, but they still have to bargain over, sort of the process. Let's say they create a new position. And you say, well, you acknowledge, well, you have the management right to create a new position, but what's the pay for the position? What are the hours for the position? Who's going to get to be selected for the position? What are the criteria for that? All those things are bargainable issues. Filing a grievance or a ULP, as Joe mentioned, you will sometimes file both. Very often you will get deferred to the arbitration procedure. The labor boards will much prefer people to go through the arbitration procedure. And sometimes there's this thing called Collier deferral at the federal level. I don't think they have it in Ohio state level, where they will defer to arbitration even if you haven't filed a grievance. If they think that if the other side agrees to waive timeliness issues, and there's a good chance that the arbitration will resolve the issue, they'll still that's called Collier deferral. They'll still send it to an arbitration. So the arbitrator has a lot of power here. It's very important to be aware of that. And I don't have any time left, so I'm going to say thank you very much. And I don't know if there's time to have questions taken off after the time, or if people just want to, if people have a hard stop at 1 o'clock. Thank you very much.
No, thank you. This was very interesting. Anyone have a question they want to submit before logging off? I do want Megan, I do want Brian to stick around for sure, just for a minute if they can. Obviously, we want anyone that hasn't recorded their CLEs in the last few moments. Chris, did you already put that out there for folks to put their CLEs in the last few moments?
I did for the last half hour. So if you have not put it in yet for the last half hour, please do so. And we do have a question for Mr. Becker. Whether, did you say, I think you did, that you were planning to send us a copy of your handouts?
Yes, I can send you all my handouts.
Yes, please.
As soon as
And
we
then we'll
sign off today, I can send those, and hopefully you guys have a method of getting those out to participants.
absolutely. Yes, we will get
Great.
them on out to everybody else. Thank you.
Perfect. And if you haven't already, just one last plug. We do have a session coming up this Tuesday for our regular monthly Colera session. It is titled Our Student Athletes Employees. We have Naima Clark from the NLRB presenting, and there are our emails coming out to our members, but I'll go ahead and drop that into the chat right now for everyone. If you haven't received that email, you can register for that event now and hopefully join us on Tuesday. Ooh, I'm sorry, that would be the wrong one. I will drop it in just a moment. And once again, Brian, if you could stick around, and Megan, just because we want to make sure we get your CLEs corrected before you guys log off, I would appreciate it. I know you guys are probably in a hurry to get going, but one last time, I want to thank both our speakers. It was very interesting information. I was taking tons of notes today, and very informative, very interesting. So thank you. And I'll put that Lyra link in just a second.
Thank you all for having me. I appreciate it.
Thank you.
All right.
Same here.
Take care, everyone.
Thank you so much for speaking.
Absolutely. Thank you all.
Okay, and before you go, Joe, you had a question about physical address. I'm so sorry. I don't know our physical address. It's kind of a weird thing because we're all like different entities. We come together as a community, and it's a weird question. I probably have to defer to our secretary, Don Collins.
That's okay. It's not a big deal, Kate. I think we actually have the Illinois address in our system already just to record this as a meeting. So I'll just use that. It's not an issue.
Yeah, Bernadette is, I think that's Bernadette's location, right?
It's Bernadette and Emily both. They both are there in Illinois together.
Yeah.
Location. I apologize. As far as Ohio, we don't really have a physical location.
That's all right. Yeah, that's okay. Thank you so much, though.
Thank you.
All right, take care.
Thank
Thanks,
you.
Joe.
All right, see you later.
Megan has recorded 2 times for your CLE and able to.
Yeah, sorry.
I
I
don't
didn't
know
know
Jump
if
in
you,
the car and I'm
We
on the
weren't-
app on my phone.
yeah, we weren't sure if you had seen our message and we wanted to make sure before you logged off that you made the attempt to screenshot stuff.
Are you driving?
Yeah,
right
I just took a screenshot of those 2 that I have.
Do you
Okay.
actually send those to Supreme Court?
What she'll need to do is just send them to me, because I'll be the one that actually uploads the data into the Supreme Court. So if she sends them to me, I'll make your certificate up and send it on off.
And
Yeah,
then,
you know, it's kind of, I've like already maxed out my hours for the year, so it doesn't matter, but you always want to kind of like accurately report, be like an overachiever.
I was gonna say, I always like to have my buffer of them, so do not feel bad. I'm the same way.
okay, I was gonna say, and then we got your last one. So you only went for a total of 3, right, Chris?
No, he had one at the very, very beginning.
Oh,
I had one of the
Yeah, I know there were a couple prior to that
I was-
1241.
Hold on
time as
here. I'm
well.
trying to scroll through real quick because I swear he put it in at the
I
beginning.
had one at 11:16.
I know Megan caught 2.
Yeah, and that would have been 11:16 would have been the first half hour. I have that one. And then I think I have the
11:42.
last one that you put in at,
Yeah,
That's when I saw rolling.
11:42. And then I did it twice. Once I realized I was making a mistake, I had 12:11.
I have your 12:45. So I have the first half hour and the last half hour.
We just have the 2 in between that, I think, Megan.
Oh,
got.
Yeah, I think
45.
I just need the 2 in between. please.
Perfect. So if you're able to capture those on screenshot, Megan, you're not.
I was gonna say, one of us is gonna have to stay on the computer with her until she knows she's got them, because the minute we log off, she'll get bumped out. So
Well, will they stay? Can I send the screenshots?
Oh,
do
Yeah,
you,
you should have all of them, right?
does it show that they went? Yeah, as long as it shows the time on yours.
Oh.
You gotta hover your mouse over it.
Yeah, let me see if I can get good ones and
yeah, I don't want Megan.
Mine says, I have 1245 and, oh, they're both at 1245.
Oh,
so full screen.
Sorry, I can't see before that.
See chat.
yeah, if you're driving, we don't want you
Yeah,
Oh, yeah, I am.
trying to do all that while you drive. That's no good. So,
oh, I got a lot of direct messages in here. I'm lining up as big as I can, and I'll get a couple and send them to you, Kate.
Yeah, we'll wait for you to do it. Like I said, I don't want to bump you off.
if we log off, you'll
You'll
get-
lose the chat
But it sounds like
messages.
we don't need to bother you, Megan. It sounds like we can get it from Brian. So I appreciate you sticking around for a moment there.
Okay.
Thank you.
No problem.
Thanks,
Thanks, Megan. Good Lord. A simple little task.
Oh,
I-
you would not imagine the number of times that I have accidentally, I thought I was sending the message to everyone. I sent it to one person. I thought I was sending it to one person. I've sent it to everyone. I've done it all
did
the
it
time.
at the end. I sent everyone the last message I thought I was sending. Yeah. I just did it at the very end because I was in a hurry. Thought I was sending the Lyra link and sent a different
make
message.
this-
So I did just then. So I'm with you. I hate using the chat. I generally avoid chat at all costs because I've seen it go sideways so many times.
Oh, wait a second. Looks like Megan sent one to me as well at 11:16.
You guys did yourselves a good one.
Yeah, so
Her number to you?
yeah.
Yeah, then send us that one too.
Okay, let's see.
She said she sees something twice. Unfortunately, she can't see prior because she got kicked off.
Yeah, let me.
Oh, because she had to log back on. Probably it's not letting her see it now. If she got booted off and had to log back in, it only lets you see the log from when you logged back in.
Oh, come on. Now, and my trouble is I got 3 monitors now, so I need to like, oh, Jesus.
You got to put the screen on the correct monitor before it'll take the snapshot of the correct picture. Yeah. Mhm.
Technology is fun.
Okay, so let me change this all around. Name technology brand. Okay, speaker, we leave. Apps. Oh, come on. Give me a second here. I'm on full screen. I can't even move the damn thing. It's like I'd never done this in my life.
No, I struggle with that all the time because when I connect my laptop to my two screens at home, I cannot get my mouse to want to go down to my laptop screen. I don't understand it at all. It ticks me off. It's like, I thought it was my mouse. I bought a new mouse. It still doesn't want to do it. It makes me crazy.
Here we go now. Let me get a good view of, get rid of participants, open up chat. So here.
See, and I guess I now officially qualify as old school because since we started working from home more, I use just my laptop screen and that's it. I don't use all of those monitors like you guys do.
I hate it. Like I won't travel around my house a lot. I mean, in the summer, if it's like really nice and I can sit outside for a bit, maybe. But most of the time, I hate being away from my desk because I'm getting old and my eyes are not good. And I want to be able to use, I want to close my laptop, which is annoying to everybody because when my laptop's closed, they can't hear me as well. I want to be able to use the big screens. I want to be able to pull them close to my face. It's bad.
You're right. I think I'm starting to record them now.
Is it supposed to snow this weekend?
I don't know about this weekend, but it was supposed to flurry some today.
You're gonna love this, Kate. My screenshot has a big picture of you.
God, it's probably the most common.
No, I'm gonna
mouth
leave.
hanging open to the side.
Hey, please send that, Brian. Please send
I'm
that. It's
such-
blackmail. It's blackmail material.
I'm I'm the least photogenic person, and I tell myself that's not what I really look like. The only way I get through the day,
You
when
look
I see pictures of
wonderful.
myself, I'm like, I don't look like
I'm
that.
just gonna name these Eastman 01, 02, etc.
Yeah, that should be good.
But yeah, that's probably how it started. She sent one to me.
It's her fault.
Yeah.
So you guys weren't listening at all is what I'm hearing. You guys were just
Then-
chatting away is what you're telling me. You were passing notes in class.
I talked way too much this time. I don't know what.
No, you were saying you guys are like, look at this stupid picture of Kate. Yeah, she is dumb looking. And then,
Yeah.
like, oh shit, I wasn't submitting my CLEs to
Okay,
Curtis.
so
That's what was
now-
going down. I hear it. So you pillaged another person at the the good union, the what do you guys call yourselves? The nice union has pillaged another union rep. I hear.
You're just
Yeah,
stealing
we're-
everybody.
Yeah,
We're getting a little bit of a bad reputation, I
a
think.
little bit. We're not gonna call you the nice union anymore, is what we're gonna call you something else. What the hell do you need with all these people?
You know, I mean, part of the reason I came back is I was really frustrated with Senate Bill 5. You know, I was working as a mediator. I thought I was going to lose my job as a mediator when Senate Bill 5 came out.
Now
And
you're
I've always,
screwing with everybody.
I've always kind of joked that, you know, I wanted to end my career union side. So I'm fighting for all of us. I mean, if unionism goes away, you're all out of work too. You know?
Right.
So, but I think of, you know, OEA as the front line because the teachers are under crazy attacks. And there are so many provisions in the law that are outside of collective bargaining. And so I don't know. I'm just trying,
You're building.
I'll tell you, as an attorney, it's really hard to have meaning in your life. You know?
You're building an empire is what you're saying.
Yes.
Well, what the hell are we gonna, who's backfilling her position? Has she talked about it?
What's that with the?
Does she know who's backfilling her position or she doesn't give a rat's tail?
No, but anytime we've like stolen someone, we are extra flexible and
When's she
you know,
actually leaving? I haven't heard any of this. All I
Yeah,
saw is that she's going to,
it's gonna be sometime in the next couple of weeks. She was going to give. I've got one more. I've got 3 screenshots, so I'm almost there.
I'm just gonna keep distracting you.
Yeah. Okay, let's see.
So who's next, Duco?
I would steal Duco in a heartbeat if I could find the right position for him. I mean, you know, one
Right
where he could be
position.
free to express his.
What do you mean the right position? You put him on the corner of
Well,
High and Broad.
One of the funny things about what I do
Yell at
here
anyone that walks by.
when I started interviewing here, it became painfully clear to me that they were looking for a management attorney, not a union attorney. My job here is to handle all the internal employee grievances. I
Mhm.
was chief negotiator in negotiations. I'm the devil here.
Sure, well,
And in fact, for our Halloween,
you dressed up as a devil.
yes, I had a couple.
In other words, you didn't have to wear anything. You just showed up as is, and
No,
they were
no,
like,
I'm,
"No,
I'm,
you came as
I'm,
yourself."
I'm a management rep, so it's like-
I've heard, when you're management within a union organization, it's pretty much the worst job
it's,
there is
yeah,
out there.
it's not easy.
No.
Okay, I've got all 4 times here. I'm gonna save this 4th one. See.
Hey, speaking of which, we're wanting to develop a very short, not like, we don't want to, the inner workings of your union, but we want to understand and kind of do, these are our 5 unions and this is how they work, basically, type thing. And, because people are like, we don't understand. And we're like, it's not really for you to understand, other than these are what union rights are and we're in a collective bargaining environment. Do you have anything that you could share with us? Like, OEA is part of NEA, and and this is generally what their bylaws look like, and they're comprised like this, and
I can get something for you.
we want to do that for each of our 5 unions, and basically make them understand how they look like, and then I don't know.
Well, it's interesting. You don't hear much of me through scope because it's one of only 700 locals
Right.
that we have. I mean, it's insane. The volume here.
Yeah.
At OCSA, we had 16 locals. So, you see the state union, I mean, it's so big, and it's really the bulk of our work, but we still had 15 other locals, some of them with the state agencies. But a good share of them, were with local entities and that. But with 700 locals, I mean, we have the city of Columbus. It's like, well, you're having a strike with OEA in the city of Columbus. It's like, no, the strike is with CEA. Because
That doesn't, none of those words really make a lot of,
Well, it's a 4,000 member local. They don't need us. They could be a local on their own. They
right.
make decisions on their own. We give them advice. They may say, okay, we're going to listen to you, or they may say, no, we're mad at you. We want to disaffiliate from you.
Right.
So it's like we're a second tier, really, more than the primary union.
I always figured you guys were kind of a little bit like FOP, where they've got the lodges within
Yes.
the FOP.
Yeah.
Was the way I always thought of it as, and
No,
where
that-
some schools districts might need full service, the others don't, like Columbus, like you were just describing.
You hit the nail on the head. That's exactly where we are, and then the NEA or AFSCME is like another layer up. Now, within our internal documents, like one of my big jobs here, Kate, is to review internal business documents that include the Constitution and bylaws, to make sure they're in compliance. And there are usually levels of disputes. If they're having an internal issue, they try to resolve it locally. If not, they elevate it to us. If we can't resolve it, then we elevate it to NEA. I mean, that's the way AFSCME works. We have a little bit of more autonomy here. We don't appeal everything up to NEA like AFSCME does. But it's a really interesting structure. We just got a lawsuit really that originated out of CEA on fair share fees. We were the named party, but our international is paying for attorneys out of Washington, DC.
Oh, wow.
To assist us. So it's really a CEA issue, and it was because of CEA's decisions we're in the suit, but because it could have national implications, it gets elevated. So it's really fascinating, and you could know labor law, but to be on union side, there's no substitute. It's like how do you deal with the internal issues? So I would say 50% of my job is dealing with the internal business issues and disputes internally.
Trying to have a set of processes and a structure where
Yeah,
it works.
and it's all
So that you guys can work as if you're an agency almost.
Yeah, and you know, and then you have a mixture of state and federal laws. You know, we're governed by the NLRB through our associations with the NEA. So, you know, I'm frequently looking at like, well, how do federal laws apply? It was like, you know, today we were hearing about unfair labor practices under the NLRB. I had never done one until actually I did one at OCSA under the NLRB instead of SERB, but it's and there's a lot of similarities, but there are slight differences. You know, because we're we're a legal entity, we're a corporation, you know, we're dealing with corporate laws, you know, compliance that way. So I don't know, it's fascinating. And you know, if you don't have the experience, you're never, you know, I can't learn in law school what I need to know to do this job.
They don't teach anything in law school. Don't get me started.
No, nothing useful.
Teach anything in school.
They teach you how to read case law and hypothesize, and that's it. But all the practical stuff you'll actually use, no.
Thing in general, ever in life. You go to school to go through the rigmarole, and then you got to go into life, right?
You pay a lot of money just to get a degree that says you still don't know anything.
Right. And then your boss says, forget all that.
I always like to say, you know, the difference between someone that's smart and someone isn't is a smart or a person that's not smart thinks they know everything, and a person smart realizes I really don't have a clue you know, about anything at all. So I just shot those to you with Chris, did you want those before Kate?
I was going to say, did you send them via text or
It's out the pictures. You're
out the pictures. And put the picture on fire, Brian.
well, this one you're smiling really nice.
It doesn't matter. I'm not photogenic. It doesn't matter if I'm smiling or not. All right, I gotta go to the bathroom.
Did you send it by email, Brian?
Yeah, I send it to Kate. I can.
Oh,
Yeah, can you forward it to me too, please?
Hold on a second. Wait.
yeah. Chris is the important person to get that stuff to. She's the CLE person.
No, I'm just the lame one that's willing to do this, drive myself nuts.
I used to be the lame one, and then
I've only done CLEs where I did a presentation and submitted all this stuff a couple times. Kate, you really do a good job.
no, I don't do it anymore. Chris is the person that I gave that up. I did my time.
Chris, what is your email?
It is CHRI, S as in Sam, TINA dot Hasselberger, HA, S as in Sam, EL, B as in boy, ER, G as in George, ER, at das.ohio.gov.
Burger at
das.ohio.
DAS.
.ohio.gov.
Here you go. You're gonna love these pictures of Kate.
Oh, God damn. Beast man. All right, I gotta go. Have a great
Thank you.
Goodbye.
Bye.
You're actually getting my whole screens here. I hope
Oh
you see
my
these.
God.
We'll live, I'm sure.
You're gonna have to. I just sent them.
Okay.
And
All right, don't forget to send me some fun stuff about OEA.
okay.
We're gonna write some fun trainings about the unions. We'll make you guys the fairy godmothers of them all.
Okay.
Goodbye.
There should be 4 of them, and then one of those